Hello, I'm Thomas Hare, Chief Content Officer of the Performance-Driven Marketing Institute, a not-for-profit trade association that serves companies in the performance and direct-to-consumer marketing world. Welcome to the third and final event of our fall seminar series, today created by the PDMI's Government Affairs Council, the FTC's Q4 Crackdown. We welcome all of you to today's event, PDMI members and non-members alike. Speaking of membership, if you're not a member but are attending today, we'd love to have you consider joining. There's no better way to support the mission of the PDMI than joining and sharing your voice in the direction of the industry. In the handouts tab of your control panel, you'll find our PDMI membership brochure. I urge you to download it, flip through it, and contact any of our team members should you desire more information. Before we get to today's conversation, one other housekeeping note. The group will be addressing any questions from the audience at the end of today's session, but you don't have to wait to ask them. Utilize the questions tab on your control panel to type and send your question in. We'll be collecting them and we'll try to get to as many as possible in the final moments of the webinar. And today's webinar, from compliance with its endorsement and testimonial guides to targeting multi-level marketers and other money-making ventures, and to ramping up its focus on so-called dark patterns in marketing and messaging, the Federal Trade Commission has spent much of the year's fourth quarter putting performance marketers on notice. Today, Linda Goldstein, co-leader of BakerHostetler's advertising, marketing, and digital media team, and a member of the PDMI's Government Affairs Council, welcomes fellow BakerHostetler partner and former acting director of the FTC's Bureau of Consumer Protection, Daniel Kaufman, for a one-on-one chat about the Commission's recent activities. Daniel is trying to get that webcam to work, but we do have him by voice loud and clear. So, Linda, I'm going to throw it over to you. Thank you both for joining us. Take it away.
Thanks, Tom, and thanks to everyone that's joining us. I know many of you know me, but I'm really excited to introduce you to our new partner, Daniel Kaufman, who, as Tom mentioned, very recently joined us from the Federal Trade Commission, where he spent 23 years working in the Bureau of Consumer Protection, and most recently as the acting director for the Bureau of Consumer Protection. And you know, people say timing is everything, and boy, did we time this right, because I can't think of a better time to have someone who has the insight into, you know, what this current administration is doing and where they may be heading, than having Daniel. I've sat across the table from him for many years, and I'm delighted for us to be on the same side now. And really, we thought it would be an opportune time to do this webinar because really, as Tom mentioned, the last few months under this new administration, we've seen some of the most aggressive activist activity coming out of the commission than certainly I have seen in my entire career. And we're gonna cover a lot of ground today. We want to give you a sense of, you know, kind of what the makeup of the current commission is, you know, what some of the current thinking is. And then we particularly want to talk about some of the recent actions that the FTC has taken that we think, you know, have a direct impact on members of our industry, of the, you know, direct response, direct marketing industry, which include in particular the letters that the FTC recently sent concerning testimonials and endorsements, because that's such a significant component of almost every, you know, direct response campaign. We want to talk about specifically the policy statement that the FTC recently issued governing negative option marketing, which includes your continuity programs, your free trial programs, your automatic renewal programs, some of the letters they've recently sent relating to income statements or income earnings, which affect a certain segment of our industry as well. And then hopefully you'll have an opportunity. I should say that the current chairman, Lina Khan, has put a ban on having folks from the FTC speak publicly. So hopefully with Daniel here, you'll have about as close an opportunity as you can to get some insight into, what the FTC is thinking now. So please, we're definitely going to save time for questions at the end. Feel free to send us your questions. So let's start first, Daniel, if we can, about some of the recent letters that the FTC has been sending out. Can you give us some background so our folks can understand, why is the FTC suddenly doing this? We haven't seen these kinds of letters. What does it mean if you were a recipient of one of these letters, or even if you weren't, kind of what should you be doing now? And really, what's behind this love letter writing campaign?
Yeah, thank you, Linda. I'm really glad to be here, and I apologize that my webcam is not working. Had I known that, I would have stayed in my pajamas today. But I will move on and start talking about these letters, and I'm going to try not to do too much of an FTC wonky thing, but I think the context is really important to understand these letters and what they mean and what they're at. And the starting point really is the Supreme Court's AMG decision from about 6 months ago, which severely curtailed the ability of the FTC to go into federal court and get monetary relief. There are other situations where the FTC can get relief if a statute authorizes penalties, if a company violates an administrative order. But the genesis of this letter writing campaign is there is another provision in the FTC Act. I'll spare you sort of the citation, but that allows the FTC to seek civil penalties if they can show that a company currently is violating some sort of practice that the FTC has previously deemed in an administrative action is unfair or deceptive. It's a pretty complicated process. You're used to sort of, if a company violates its own order, the FTC can go after you for civil penalties. But in effect, what the FTC is trying to do here based upon this authority is based upon old FTC decisions, and literally we're talking about decisions from the 40s and 50s, using those decisions to create these principles and then go after companies potentially for civil penalties. And it's I would say it is a big deal what they're doing here, but there also is a lot of vulnerability and challenges to the FTC actually following up on these letters with enforcement actions. So it's definitely a strong shot across the bow by the FTC that we're going to use every tool we can to try to get monetary relief, in this case, civil penalties. Civil penalties are the only thing you can get from these letters. And it's definitely a strong statement from the agency, but there's a huge uphill battle. And I can go through, Linda, if this would be helpful, sort of how the FTC would sort of implement this, because stage one is the letters, but there's a lot more behind it.
Yeah, I think that would be helpful. I just want to add, just for a bit of context, in case some of the folks listening may not be as familiar with the AMG decision as we all are, because it was a long-awaited sort of groundbreaking decision. But I think most of you know, because our industry has been a huge target of this, that for decades the FTC has been able to run into federal court to sue companies, and in many cases, particularly in the telemarketing area, they often could get asset freezes as well, where they could run in, freeze the assets of the companies and the individuals, take over the company and appoint receivers. That was all done pursuant to a certain provision of the Federal Trade Commission Act, which, and we're not going to get into the legal details because, as Daniel said, it's too wonky, but essentially what happened is that the Supreme Court unanimously ruled that the FTC actually never had the authority to do that, because the provision of the FTC Act that they were relying on only gave them the ability to obtain an injunction, not monetary relief. Now, that doesn't mean the FTC can't get money, because the FTC Act does provide other ways for the FTC to get money. One of them is, sort of going through an administrative procedure, but that's much more cumbersome and has certain limitations on it in terms of, statute of limitations, and that provision is a little bit more favorable to business than what the FTC has been doing. But this is a sea change for FTC enforcement. And so what they're looking to do is to get money any way they can. And I do want to say, before we get into the letters, that some of the other ramifications of this that we all should be particularly aware of as an industry is that the FTC is also going to be looking to all of its trade regulation rules, because those provide civil penalties. So your email marketing campaigns, like, that are subject to canned spam, the telemarketing sales rule, which would, govern outbound and both inbound sales calls in some respects, those also carry civil penalties. And so to the extent that you're engaged in any activity that's subject to a trade regulation rule, that's an area the FTC is going to be very focused on, because it's an easy road to money. And these notices of penalty offense authority, as Daniel mentioned, they are also another easy road to money. So just want you to have that background, that while we're going to focus on some of the letter writing campaigns today, there are other things we're already seeing the FTC do that you should all be aware of in terms of just taking stock of your current marketing practices, and particularly if they fall under an existing trade regulation rule, making sure you're compliant, because that's going to be low-hanging fruit as well. But now, sort of turning back to these letters that the FTC sent, yeah, Daniel, maybe kind of starting with the testimonial and endorsement guides, if you could maybe talk about that and what the FTC's process would be, that would be great.
Yeah, no, thanks, Linda. And you're right. The FTC is basically looking behind all the seat cushions to find any authority that it has to get money. And that is precisely what we're seeing here. So there are 3 series of letters that the FTC sent out. And probably the most important one, well, not the most important one, but the one I wanted to talk about first is the one involving endorsers and testimonials. And in the notice letters that the FTC sent to, I think it's 700 different entities, the FTC lays out, it's really principles that derive from previous FTC administrative cases. And this is where I talked about, the cases from the 50s and 60s. And what makes this authority sort of interesting is the FTC can't rely upon federal case law. So what they're doing is they're looking at very old administrative case law. There's an administrative tribunal at the FTC that they do not use very often now, but in the 50s, 60s, and 70s, a lot of cases were brought administratively at the FTC. So the FTC is mining those old cases to get content for these letters. So the notice letter on endorsement lays forth some pretty well-established principles on what you can and cannot do when it comes to using endorsers or testimonialists. For example, it says it's unfair or deceptive to use testimonials to make an unsubstantiated performance claim. So you can't, in the weight loss area, you can't have a testimonial saying I lost 100 pounds when that's not the typical result. So it's sort of pretty straightforward consumer protection principle. Or it's also a deceptive practice if you fail to disclose a connection between an endorser and the advertiser. Again, these are pretty well-established consumer protection principles, but the FTC is now taking it and trying to convert it into a tool for civil penalties. And what would happen if the FTC, let's say they went after a company in 2022 using this notice letter? There's a lot that the FTC would have to show. First, they would have to show that the conduct they're challenging in 2022 or 2023, whenever, is similar enough to the old conduct that the company had noticed that the conduct they were engaging in currently was deceptive or unfair. And what makes this particularly challenging and interesting, well, I guess challenging is the right word, is that they're relying upon cases from the 40s and 50s to bring forth these principles. And the market and the economy and influencers and endorsers are so vastly different than what we see now. So there's some good arguments that can be raised and will be raised if the FTC does this, that you really can't rely on these old cases for these propositions in the 2021 economy. But that's what they're doing. They're taking these old cases and converting them into principles to put companies on notice. The FTC would also have to show that the company they're going after currently had actual knowledge that the FTC had previously decreed these practices to be unfair or deceptive. And that is why you're seeing the letters. The letters are a vehicle for the FTC to show actual knowledge. Actual knowledge is a very high standard, and the statute doesn't explain how you go about proving actual knowledge. But from the FTC's perspective, if they send a letter to a company saying, don't do the following conduct, that gets them certainly a lot closer to being able to show actual knowledge. So what would basically happen is the FTC would start off an investigation of a company, and as part of the investigation, they would have to prove up that the company had knowledge of this notice letter and the concepts that are embedded in there. So it's a high burden for the agency, but it's something that I think the agency will be proceeding in some fashion. It would be very odd for them to send out what was a total number of 1,800 letters and not do any follow-up. So although the letters themselves are not enforceable, there's no indication of any direct enforcement action on these letters. The reality is they're looking at this, and I have to imagine we'll be using this down the road in some enforcement actions. And I would imagine the next cases or investigations involving endorsers and testimonials will absolutely be focused very much on these letters, and the FTC attempting to use these letters to not just say that the company violated Section 5, but that they violated these letters, and therefore the FTC can now get civil penalties. So it's a complicated process, but one important thing to keep in mind, even if the FTC is unsuccessful in being able to show actual knowledge or to show that the company knew that these practices were unfair or the current practices are too dissimilar from the old practices, the FTC still can go after companies under Section 5, regardless of the letter. So the concepts in the letter are pretty well established Section 5 principles. So you can't misrepresent or make unsubstantiated claims with testimonials, things like that. But the letters really do ratchet up the potential threat level.
Yeah, and again, and just to get into the substance of the letters a little bit, where one, I think whether you're a company that received the letter or not, this is clearly a warning bell from the FTC that we're going to be seeing renewed enforcement of the testimonial and endorsement guides. And along with that, I think one of the things our members should be aware of is that the FTC continues to take a very, very broad interpretation of those guides. So, just in terms of your own advertising, whether you're talking about consumer testimonials or, you're actually hiring influencers to do things in social media, these guidelines, in addition to what Daniel mentioned, which is that none of these endorsers or influencers can make any claims about your products or services that you couldn't independently substantiate. You also need to disclose whether the endorser or the influencer has been paid for that endorsement. And I want to make clear here, if you get a letter in from a consumer and you want to use it in your advertising, you didn't pay for that endorsement to come in, but you're going to pay something for the ability to use it. That's not the kind of compensation that has to be disclosed. However, if you do, for example, bring in, let's say you're doing an exercise program, and you want to bring in 30 people to be in a user group, and you're paying for them to have a trainer, and you're giving them free equipment and free product and all these other things, even though part of the reason you're using that user group is to be able to substantiate claims. To the extent you use people within that user group in your advertising to deliver testimonials, all that free stuff that you gave them, that is going to be considered a form of compensation by the commission that's going to have to be disclosed. So you do want to think carefully about how you're engaging with these endorsers, because it's going to trigger disclosure requirements when you eventually get to your advertising. And again, we now know that this is going to be an area of heightened scrutiny by the FTC. And again, it's not just paying them, it's giving them anything of value. And the other thing I want to mention, because we're seeing so much more of this in direct-to-consumer campaigns, is the use of consumer reviews. And the FTC's letters, these letters specifically on the testimonial and endorsement guides, also talk about consumer reviews. And maybe Daniel, you could just talk a little bit about some of the principles that were in those letters as they relate to the use of consumer reviews.
Yeah, it's interesting. The notices themselves did not use the word reviews, but the FTC press release and the FTC letters that went out made it very clear that reviews are basically endorsements and testimonials. And I will say the FTC view, as important as endorsement and testimonials are, there is a realization that reviews are so important to consumer purchasing decision, that to the extent that a company is skewing the marketplace on reviews, that raises real issues for the FTC. So to the extent that whether it's employees posting reviews without disclosing that they're employees, or companies encouraging people or compensating people to provide reviews without disclosing that, that is an area of real concern at the FTC. And I think even more so than the issues of disclosing material connections, reviews are such an important part of the new economy and how people are making those purchasing decisions, that it's important to keep in mind that although the notices don't say the word reviews, reviews are definitely covered when you think about endorsements and testimonials.
Yeah, and just as the FTC has, taken a very broad view of what is an endorsement, with respect to consumer reviews, it's not just that the reviews have to be accurate, but we're seeing a lot of attention focused now on how are those reviews being solicited, and in particular, if you're using, some of these companies that can gather and aggregate consumer reviews for you, you want to do some due diligence on how are those reviews being verified. Again, remember, the reviews themselves can't contain claims that you can't make on your own. How are those reviews being solicited? Another, again, are people being paid for those reviews, in which case that would have to be disclosed as well. And the other area with consumer reviews that's getting a lot of attention as well is, are you representing the reviews in the proper context? So for example, if you make the claim that you have the most, 5-star reviews of, anyone among your competition or whatever, what's the framework? Are they reviews on your from your own website? Are they reviews across, third-party websites, including Amazon? And there's a lot of discussion now, both at the FTC and as well as at the NAD, the National Advertising Division, which is the self-regulatory body, about providing a context for consumers when you're using you know, sort of the amount or number of 5-star reviews you have, to put it in some proper context for the public to kind of get a sense of, you know, where those reviews are coming from. And also understand that if you know, design, you know, particularly on the web, if you use reviews in your advertising and you're only featuring 5-star reviews, but that's not kind of representative of what your reviews look like, that's something that may come under scrutiny as well. So I think we'll close out this piece just by saying whether you got these letters. Obviously, if you got these letters, one of these letters, you're low-hanging fruit for sure. But even if you didn't get these letters, now is the time to look at your policies with respect to how you solicit and obtain both testimonials or influencers, how you're using consumer reviews. And if you are using influencers as part of your, particularly as part of your social media campaigns, the FTC has also made clear that there is a duty to monitor. So you should be looking at what your agreements with your influencers look like and what policies and procedures you have in place to monitor them. I want to mention that another category of that the FTC sent letters on was in the area of earnings claims and income claims. And while a lot of that was directed at multi-level marketers, some of those letters were also sent to gig workers. And I think to the extent that you're promoting services in the coaching or training area or real estate opportunities or work at home opportunities, the guidance that the FTC sent out in those letters is going to be applicable as well. And maybe Daniel, if you just want to touch on what some of the substance of those letters were.
Yeah, no, and it's very similar to what we're talking about. Again, they're relying upon very old cases to describe some pretty familiar consumer protection propositions. So in the money-making area, it's deceptive to misrepresent, you know, that consumers are likely to make a certain amount of money. Those kinds of claims are what are the focus of this sort of money-making opportunity letters. It's unfair to represent or deceptive to represent that a substantial number of consumers have made or will make the certain amount of profits or earnings. There can be also concerns about the ease of engaging in the practice, the percentage of participants who get jobs. So those sorts of core money-making opportunity claims that the FTC has challenged over the years are described here. And again, much like the endorsement letter, this would be a vehicle for the FTC to potentially get civil penalties when they're investigating a company potentially making deceptive money-earning claims. So it's, again, the same principles we're talking about apply. These are old cases. They may or may not be successful, but it is an indication from the FTC we're going to use every tool we possibly can to try to get money in these cases. I should also say one of the other tools the FTC is doing, although their monetary authority is limited, they're also partnering with states in some contexts. So the state's authority to get money is not affected by the AMG decision. So the FTC can partner with states that have monetary relief and let the states get the money and the FTC gets the injunction. So it's really a very different mindset than what we've seen in for many decades now. It's both partnerships with states, it's these new letters. And I should also say, we've talked a lot about the actual knowledge standard. First step the FTC will do is, even if a company did not receive the letter, I'm sure they'll be asking a lot of questions. Did you read articles about it? Did you find out about it from colleagues? So there is just a lot of interest here. So I know we're maybe at the halfway mark. Linda, maybe should we switch it up and talk a little bit about policy statements?
Yeah. So the other big action that came out just a few weeks ago, and I think for our industry, again, this is a game changer, is the policy statement that the FTC issued on negative option marketing. And really there are, well, I should say there are two things that have happened around that. And I think it's a game changer for our industry because, like testimonials and endorsements, so much of our products or services are sold via some form of negative option marketing, whether it's an automatic renewal or continuity or some type of a subscription service. These are all going to be considered forms of negative option marketing. And I think, as most of you know, since 2010, the FTC has had a strong tool in its toolbox in the form of ROSCA, which is the Restore Online Shoppers Confidence Act, which governs all forms of negative option marketing online. But there have now been basically two things the FTC has done to greatly expand its authority in this area and the risk to every marketer who's engaged in this kind of marketing. The first is that in a recent case that was brought against a company called MoviePass, the FTC has basically said that if any part of an ad that has a negative option component to it is misleading, even if it doesn't relate to the negative option feature, they can bring an action against the company for violating ROSCA. And that means, again, for those of, just as a refresher, ROSCA had three simple requirements. You had to have notice of the material terms and conditions, the consumer's affirmative consent to the transaction, and an easy method of cancellation. And historically, the FTC would bring actions under ROSCA if a company failed to do any or all of those three things. But in this MoviePass case, basically what the FTC said was, even if you did everything under those, even if you complied with those three ROSCA requirements, if you said something else in your ad that was misleading, and in the case of the MoviePass case, it was they misrepresented essentially how many passes you would get and how easy it would be to redeem your movie passes, then the entire ad can be challenged under ROSCA. And again, ROSCA calls for civil penalties. And so it's another easy route for the FTC to get money based on any ad campaign that has, where the consumer is buying the product or service that's being advertised under continuity, auto renew, or something else. So that's obviously a game changer. The one caveat is that ROSCA still only applies to online transactions. But in addition to that, the FTC also issued this new policy statement that they can use to bring actions just generally under Section 5 of the FTC Act. And that policy statement greatly expands on what the requirements of ROSCA are specifically, and now, essentially creates, I would say, sort of new standards for negative option marketing in every channel, not just online. And so, Daniel, maybe just with that background, you could talk a little, if you could talk about what this new policy statement is and kind of what it means for our members.
Yeah, a policy statement, it's not a rule, it's not a statute. So the FTC can't go into court and say you have violated a policy statement. They still have to show that you have violated or allege that you have violated some underlying statute, whether it's ROSCA, the telemarketing sales rule, or Section 5. But courts will look at this policy statement. The FTC is sort of laying out this overall framework of how they think disclosures should look, how consent should be obtained, and how cancellation should happen in the context of subscription services. So it's a really important document. Both it highlights, what the FTC is going to be looking at, what their expectations are, but it's not a given that courts will enforce the concepts that are in there. I mean, ROSCA is pretty bare in its language in terms of, for example, what cancellation should be like. It requires a simple method of cancellation. The statement right now lays out much more detail about what the FTC interprets that to mean. So it's obviously very important to be mindful of what the FTC is saying, but much like the letters, it's again, difference between putting it in a policy statement and proving it in court. So I do want to flag that. But Linda, I know you have dug into this statement probably more than anybody I know. So I wanted to ask you, what are the things that struck you as most surprising? There's the movie pass issue, but I know there's a lot of other issues that we've talked about that really struck you as game changers and significant deviations from how the FTC has addressed things in the past.
Yeah, yes, and I for a long time I've kind of said the FTC is putting its own gloss on ROSCA, but now they've really codified it in this policy statement. And there are kind of three things I want to flag where I think on a very practical level it may require folks to go back and look at their disclosures. The first is in terms of actually what has to be disclosed. So ROSCA says all material terms and conditions, and that really hasn't changed. But the one thing that they've added is all details concerning the cancellation policy, and we'll talk a bit later about how important your cancellation policies and procedures are. But for the moment, I think that the action item is it's probably no longer sufficient to just say something like, if you want to you can cancel anytime, by doing, and directing them somewhere. You probably need to give a little bit more detail about how they actually can cancel. The second big change has to do with consent. And as Daniel mentioned, ROSCA doesn't specify how you have to get the consent. It just basically says it has to be, express affirmative consent. The FTC has, now said in the policy statement that that consent has to be express and unambiguous. And while they didn't go so far as to say you have to have a checkbox or something else, I can tell you from all of the enforcement actions to date that the FTC wants to see something more than just hitting a submit or continue button. And I want to mention one other thing on, sort of the material terms and conditions disclosure, that the FTC has also said really the consumer should be given those material terms and conditions before they make the decision to buy, which in their mind means before the consumer gets to the shopping cart. And we've been talking about this for a while, that once the consumer gets to the shopping cart is probably too late for those disclosures to be made. At a minimum, they need to be made before the consumer gives their credit card information. But going back to the consent, the second, and this I think, is potentially a game changer. The FTC has also said that the language around the consent has to basically deal only with that negative option feature, and it can't contain other extraneous information. So you can't sandwich your disclosures in between other information that may relate to the benefits of the product or service. The disclosure of the negative option feature kind of has to be a standalone provision. And the FTC has also said in this policy statement that the consent to the negative option feature has to be separate from consent to the entire transaction. And now I will tell you, I was so alarmed when I saw this one that I actually, Daniel and I both spoke with someone at the FTC, and they clarified that you don't really, if your whole transaction is a negative option. So for example, if it's a monthly service, like a streaming service, that is the entire transaction. So you don't have to have a second opt-in. But if you're, for example, selling a product and you either, you have an option to purchase it, but as a one shot, or you have an opportunity to purchase it on continuity, the disclosure that you're buying it on continuity is going to have to be really clear. Or if you have a, month-to-month billing, but you also have some kind of a free trial, there's probably going to need to be, some clear affirmative consent to the free trial in addition to the month-to-month subscription. So again, depending on the structure of your program, many of your current disclosures and templates, they may not satisfy these heightened requirements. And then finally, on the cancellation side, I will tell you there's been a huge focus on cancellation and on the back end. And while ROSCA only requires that the cancellation be a simple method, basically the FTC has come out now and said what we've known they've been thinking for a long time, which is that the method of cancellation has to be as simple as the method of as how the consumer entered into the transaction in the first place. And they've also said that whatever channel the consumer has, entered into the transaction, they have to be allowed to cancel through that same channel. So if it's online, there's got to be an online method of cancellation. And by the way, that's something New York and California require anyway. If it's by telephone, then they have to be able to cancel by telephone. And the other thing that's very important is that they've flagged save-a-sales, and they haven't gone so far as to say you can't do a save-a-sale at all, but they've said you can't do a save-a-sale that unreasonably will delay the consumer's ability to cancel. And again, based on some of the enforcement actions we've been involved in, I think, or I'd be curious on your view, Daniel, but I think anything more than one save-a-sale is probably going to be viewed as too much in the current environment.
Yeah, I very much agree. Again, it doesn't say that in the statute, but certainly the FTC is sending a very strong signal that, one save-a-sale that's not unreasonably intrusive, that's fine. But if you're going beyond that, like really, do you want to cancel? That's going to be problematic. And, I will tell you, one of the first things the FTC will do as they're looking into ROSCA issues and cancellation is consumer complaints. And, from what I've seen in a lot of cases, this is an area where there's usually a fairly rich trove of consumer complaints about difficulties of cancellation. So it is an important issue at the FTC. It's an important issue in Congress. I know there's been discussion on the Hill as well on sort of cancellation issues. So I would expect to see a lot of emphasis going forward on FTC cases. Again, all of this is quite significant, but cancellation is a really important area.
So if another area I want to focus on, I know we're getting close to the hour and I want to leave some time for questions, but Daniel, while you were still at the commission, the FTC held its workshop on dark patterns, which very much impacts, the whole consumer buy flow online. And wondering if you could just, briefly tell our viewers, what does the FTC mean by dark patterns, and what should they be aware of now in their sales channels?
So dark patterns, it's an interesting concept. It's either described really nefariously or a little bit more nuanced, but some companies are describing it as tricks being used in websites and apps to make you do things you didn't want to do, like buying or signing up. Sometimes a little more neutrally, it's potentially manipulative interface designs on websites and apps, but it's really looking at the flows on apps and consumers, and how are they guiding consumers, and are they guiding consumers in a way that's contrary to consumers' expectations or desires. And the FTC did a workshop on it. They only do workshops when it's an important issue. They're also starting to rebrand things as dark patterns. So we're going to see a lot more coming out of the FTC on things that we wouldn't traditionally think of as dark patterns, but that are going to be called dark patterns. For example, the negative option policy statement, the press release that went out about it called it dark patterns. So dark patterns can be negative options, they can be disguised ads, but there's a whole range of conduct that is a dark pattern. And the FTC really has not laid out, which dark patterns are going to violate the FTC Act and which are okay. And there's, egregious conduct that I think it's called sneak into basket. I've heard about that on websites where consumers don't even purchase something or intend to purchase something. It's just put into their basket. So that would be a pretty straightforward dark pattern. That would be a law violation. But there are other dark patterns that are really just persuasive marketing. And the FTC certainly has not come out yet and indicated, there are some areas where it's just persuasive marketing, but I do think there are very strong arguments that some of what's being called a dark pattern is really traditional, effective marketing. But there are a couple of areas just to be particularly mindful of. If you have a website or app that has a significant presence of kids, that is an area that the FTC cares a lot about. Kids can be a lot more susceptible to dark patterns. So something to be mindful of, as well as consumers that may be, seniors or folks who might be less online savvy. I don't want to generalize that seniors aren't online savvy, because my 89-year-old mom is online all the time. But if there are language barriers, that's also an area where the FTC does care a lot about dark patterns affecting sort of subsets of the population differently. But generally speaking, if it's a dark pattern that's being used to deceive consumers or charge consumers without their authorization, that can be an FTC Act violation, and we'll start seeing them calling it dark patterns a lot more than they have done previously. It's an important term that we'll be seeing a lot more of going forward.
And one of the ones I want to call out, because it's kind of a staple in direct response marketing that they highlighted, is false sense of urgency, and they specifically talked about things like a timer on the website that suggests that this special offer isn't going to be available after 10 minutes, or indications that there's scarce quantity, like there are only 5 left of what you may be looking at. And again, we're not suggesting that you necessarily stop doing it, but it's worth a conversation and a revisit. Certainly, if those representations are false, I mean, that's going to make it an easier target. But I do want folks to be aware that, some of these things, which, I consider to be, persuasive direct marketing 101, have suddenly made their way onto the stage as potential dark patterns. And at a minimum, I think you want to just be careful if you're using some of these techniques, which we know many of you are, to make sure that there's some, it's not completely made up, because those are the ones I think the FTC is going to go after. And so you may want to think about ways to get across those same messages in a way that may make it more difficult for the FTC to challenge.
Yeah, no, it's a great point, Linda. Up until now, the FTC has used those scarcity concepts. We call it color in a complaint. There's some underlying deception, and the FTC will indicate in the complaints, in addition, they're making these scarcity claims that were deceptive. But the issue is, will they be sort of independently just going after scarcity claims, even if there's no underlying other deception. And I think you hit the nail on the head. It's remains to be seen what they're going to do, and taking a closer look is definitely solid advice.
So I'm not sure, I'm not seeing any questions in the chat, but I don't know if I'm missing anything.
Hi, Linda. We've got some. I've just been holding them back here, and I can jump in and throw them at you if you guys are ready.
Yeah.
We've got 3 or 4 in here that I think are good. Are there best practice guidelines available online to help marketers avoid being in violation of current endorsement and testimonial rules and regulations? Or also, is there a good case study or two you might recommend about the same idea?
So the FTC does have guidelines on the use of testimonials and endorsements. Those do basically lay out what the FTC considers to be misleading or deceptive. It's mostly done by way of example. So as the use of testimonials is evolving, you may not find every example in there, but that would be the best source, would be to look at the FTC's testimonial and endorsement guides.
Yeah, and that is something that the FTC has been in the process of reviewing and possibly amending. So sort of stay tuned. I would not be surprised if some proposed changes to those guidelines come out in the near future. We've been waiting to see those for a while now.
Great, makes sense. Next one, do either of you know of a case where a marketer or brand was in violation of the current online consumer review regulations? If yes, would you mind sharing the gist of what happened, went wrong, and what was the resolution?
So I'm sorry, a case involving reviews. It sounds like that's the
online reviews. Yeah.
So the most recent example that comes to mind, there's a case called Sunday Riley, which is a skincare company. And in that case, the head of the company was allegedly encouraging employees to go to the Sephora website and other skincare websites and post 5-star reviews for Sunday Riley's products without disclosing that the people posting the reviews were Sunday Riley employees. So the FTC brought a case against the company as well as the president of the company, who is named Sunday Riley, that process of having employees post reviews without disclosing their affiliation violated Section 5. And the other interesting thing about that case is that led to an administrative injunction, so no money, and the Democrats who are now running the agency dissented very strongly about the lack of money in that case. So based upon all we've been talking about today, I think if a case like Sunday Riley was brought today, it would come with some sort of financial relief. Again, the FTC is coming up with creative theories to get money. So I think we saw these cases used to have no money settlements. I don't think we're going to see that anymore. If there's any way for the FTC to get money, they will be seeking it.
Makes sense. Great. Another question. Yeah, we actually have 4. So this is the third question. With all this action at the FTC level, what's the hope, if any, for congressional action that would clarify policies and assist marketers in dealing with the FTC and everything that's going on?
So, from my perspective, I do try to listen to what's going on in Congress. The FTC has gone from being a fairly bipartisan agency to a much more partisan agency. So we're seeing a lot more Republican-Democrat divide on what the FTC is doing. I mean, just today, there's a potential new FTC Commissioner Bedoya, who just got voted out of committee. Well, he actually technically has not been voted out of committee yet, but it was a 14-14 vote in committee on party lines. So I think he will get a chance to get voted, but it just demonstrates there's a lot of congressional concern about what the FTC is doing. And there have been more and more letters coming to the FTC. So I'm not aware of any legislation yet that would really curb what we've been talking about. But I've definitely seen a lot of concern from members of the Hill and from industry as well about some of the activity we're talking about.
Mm-hmm. Yeah, I think we had a session in San Diego in October at our PDMI West show, and the conversation there among the attorneys on that panel was definitely interesting to hear them talk about how the agencies and whatnot are starting to reflect more of that divide in the country more than they ever have. So it's an interesting thing to see happening. Last question, and this was one I was thinking about asking before it popped through, or a version of it. Just how vast do you think the dark patterns descriptor is going to get? It seems like they're kind of sliding things in to under that. All things that have been regulated before, but how fast do you think it's going to get as they continue to focus on the area?
Yeah, I was surprised to see the negative option statement described as dark patterns, but it's a topical term. It's demonstrating to the world that the FTC is on the beat about dark patterns. So I really do think we're going to see a lot more that's put into that bucket. Again, it could easily be stuff that's traditional FTC stuff that they're just rebranding as dark patterns. But I think we're going to see a lot more of that. I would be surprised if we didn't. I think we could even see potential rules called dark patterns rules. I would not be surprised if that started happening at some point down the road.
And I just want to add to that. We've seen some of this firsthand already in some of the cases that are currently we have in litigation with the FTC. I actually think it's happening pretty quickly, at least on the enforcement side. And just to share quickly one war story, we just completed a case with the FTC where, historically, the standard as to whether advertising was misleading or deceptive is what is the consumer, what messages is the consumer taking away from the advertising. And in this case, which was, really about claims being made on the website, the FTC didn't bring in any evidence of consumer perception of the advertising. They brought in an expert whose research was focused entirely on the user interface, and the evidence of the study that the FTC relied on to argue that the websites were deceptive was an increase in conversion rates. And to me, what's so alarming about this is, where do you draw the line between effective advertising and deception? And the FTC seems to be operating from a premise that if you have techniques in there that increase conversion rate, there's almost a presumption that it's deceptive. And that's, again, I think that's just a very dangerous path to be going down. But we're seeing it. It's here, at least on the enforcement side.
Yeah, it's tough. I'm going to come back on the screen here. It's interesting. We heard a lot about that in October as well. That what. In the past, I think one attorney said, my client said, well, that's just effective marketing. Where's the line? The line has shifted so far in another direction. So, well, thank you, Linda, for pulling this together. Thank you, Daniel, for joining us. We really appreciate it. Thank you to the Government Affairs Council for their efforts in bringing the event to us today. Just a tremendous amount of information, and we look forward to sharing this once we've got the video pulled together online in the next couple of days. So as a viewer, your next opportunity to attend a PDMI event live online is our next episode of Take 20, the 20-minute webinar series created by our Brand Response Council, which will air live next Wednesday, December 8th at 2 o'clock Eastern, 11 a.m. Pacific. Visit thepdmi.com/take-20 to check out our upcoming schedule and register to attend. The Workshop Council's Winter Seminar Series kicks off with a one-hour event on December 15th about lead generation marketing in the insurance business. Keep an eye on your email, the PDMI's website, and social media tomorrow for more information about the topic, the speakers, and your chance to register. Thanks again for joining us today. Enjoy the rest of your day and the rest of your week. Be well. Take care. Bye-bye.
Bye, everyone. Thanks.
Thank you so much.